Have you ever heard the word probate and thought, oh, I want to avoid that at all costs? Well, it's kind of like a four-letter word for many people. So today, we're going to answer the question, is probate really as bad as it's made out to be? I'm Ethan Huizenga, host of the Siouxland Senior Planning Radio Show and attorney at Huizenga Law Firm, PC. If you're looking for more tips and tricks around estate planning and elder law issues, make sure to hit the like and subscribe button below so that you never miss any updates. Let's start by talking about what probate actually is. Probate is, quite simply, the court-supervised process of administering someone's assets or potentially their personal decisions. In some cases, probate happens while a person is living. We call those cases guardianships and conservatorships. Sometimes we might refer to that as living probate. But when most people talk about probate, they're referring to the case that is opened when a person passes away. That case happens in the local district court in Iowa and is going to involve basically three main steps. Number one, it's taking control of the assets. Number two, it's going to be resolving any creditor claims and paying debts, taxes, things like that. And then number three, it's going to involve distributing the assets to the people who should receive it. Some people think probate is a necessary evil, kind of the process of supervision over a person's estate when they pass away. It can be particularly useful to go through probate when there's a complicated set of family relationships or maybe conflict among family members, or maybe it's just a complex financial picture that needs to be untangled with the help of the court system. But there's a flip side to going through that process. And that primarily is related to the fact that it's a court case. Probate in Iowa can be time-consuming, sometimes taking months or even years. In fact, normally we expect that a case should take at minimum 6 months. But even then, it's almost impossible to get a probate done in a year unless everything falls out just perfectly. Because it's a court case, probate can be expensive. You have court costs and lawyer fees, and there is notice and publication costs and additional administrative expenses that get involved when a court is supervising the case. When somebody dies, there's other expenses as well. These aren't necessarily exclusive to probate, but when you add the probate fees on top of these other administrative expenses, you can see that the probate process becomes very, very expensive. And as if the time and the cost weren't enough, probate can also be a very public process. As a court case, it's a public proceeding, and so all of the deceased person's financial affairs are published in the court record. And for a lot of people, that level of transparency just isn't particularly comfortable. So then the question becomes, is probate inherently bad? And as a lawyer, my job is to tell you that the answer depends. It's going to be different from person to person and situation to situation. For some people, the court-supervised process is reassuring. It gives a sense of security. But for others, the costs just completely outweigh the benefits. Fortunately, for people on both sides of the issue, there are estate planning tools and strategies that can help you ensure that your estate is administered the way you want to see it done. Revocable living trusts, joint tenancy or joint ownership, and beneficiary designations are all ways that you can arrange your affairs in order to make sure that they pass to the people you want, the way you want, and at the right time. Thanks for listening, and we'll see you next week for another episode of Siouxland Senior Planning.